Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Am I on? Okay. Hello, everyone. We are back. My name is Pam Esquire, also known as Your Law Intellect. We actually were just together watching the Nesto bond hearing or attempt to reduce a bond. And now we are back to talk about Ira Kelly or Robert Sylvester Kelly. I was just minding my business, and as I always do, trying to do the work and help the people. And something came across my desk. I saw a press release from R. Kelly's attorney. And, usually I try to wait to see if an actual lawsuit is filed, because sometimes attorneys, they will file press releases and don't actually file a lawsuit. So I'm very skeptical, when people start out with those press releases. And then I looked, and lo and behold, they filed a lawsuit. What are you talking about, Pam? Well, what I am talking about is that R. Kelly has filed a lawsuit with various allegations against the United States of America and different BOP, John and Jane Does. But the only name that he really knows to put on that pleading is Latasha K, aka Tasha K. Somehow, Tasha K has gotten into another lawsuit, another legal battle that will require another attorney. And we are going to get into that in about 2 seconds. Let me plug up my laptop. You guys hold on. Please make sure you hit that like when you come in. Subscribe to the channel if you have not done so already. Thank you to everyone that has already hit the like. Thank you to those that were just with me at 5 o'clock and now you're coming back an hour and a half later to hear me talk again. I appreciate you. Let me go ahead. Give me 1 minute. I got to plug this up right quick. Sorry about that. It literally came out of the wall. For those of you that's going to say, you're so unprepared. It came out of the wall while I was talking. So anyway, welcome to everyone. Shelby, Elaine, Miss V. Good to see you as always. Thank you for supporting Pamela, Walker, and Alice. Thank you so much. Let's see. Thank you so much for coming in and watching. Betty. Sunflower. She was rocking with the other one. Jaleisha, thank you so much for coming back. Elaine, Michelle, you just came back. Thank you, Michelle. I appreciate it. Precious Gem Jean. I see a lot of faces that I saw earlier. So thank you guys so much for coming back and supporting on this video as well. I don't know how great the algorithm is going to be because we had about 1,800 on the last video. So YouTube might tell me to kick rocks that I'm being greedy, coming on more than one time, which means I'm going to get a bunch of texts. You went live? You talked about it? I didn't get a notification. I'm going to get a lot of those, especially from my family that's going to swear they never got a notification. So I don't know how great this is. So if you guys make sure you like it, then it'll get me in the algorithm so people will know that we're back at it and that we're back on. And yeah, thank you, Allison. Allison said, I'm back. Thank you. Stephanie, thank you. Thank you so much for returning. Thank you. Thank you. So yeah, I'm gonna pull up this lawsuit because it is 25 pages. And we're going to get into and I guess when all of this stuff happened with Tasha K and the R. Kelly, I didn't really follow it. So I'm going to be learning. Some people ask me about the lawsuit and what it's about and all of that. I am literally going to be looking at it at the same time as you guys because I just did not have time to look at it before. So hopefully it ain't nothing on here that shouldn't be on here. So this is the lawsuit. He has filed it in Northern Illinois. It's Robert S. Kelly versus the United States of America. He went large, okay? He said, go big or go home. Unknown BOP Officer A, so that's not a name. Unknown John and Jane Doe, BOP officers, and Latasha Kebe, also known as Tasha K. So again, I say, the only identifiable name on this pleading is Tasha K, which is just crazy to me. So we go on here and it has, the intro. Let's go with the intro, okay? Plaintiff sues the United States of America, the unknown BOP officers, also known as Officer A, unknown John and Jane Doe BOP officers, and Latasha Kebe for negligence, invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton conduct brought under the Federal Tort Claims Act. Plaintiff also brings suit against the defendant, BOP Officer A, for violation of the Computer Fraud and Abuse Act, known CFAA. Plaintiff is a high-profile prisoner of the Bureau of Prisoners, BOP. He is a Grammy Award-winning recording artist and a nationally recognized celebrity. As with all prisoners, but particularly because of plaintiff's status, the United States of America, through the BOP, had a duty to protect plaintiff and his private and sensitive information to ensure that its employees did not exploit plaintiff for financial gain or for any other reason. The defendant, United States of America, breached its duty of care to the plaintiff when it allowed countless BOP officers to access plaintiff's confidential information without any legal basis to do so. The defendant, United States of America, knew that defendant BOP Officer A and other defendant John and Jane Doe BOP officers routinely access plaintiff's private information from its systems and divulge private information to third parties for monetary gain, clout, or simple harassment. Because the United States of America, okay, somebody's asking, I think, why the names are not on there. They don't, you do John and Jane Doe when you know that there's a person, but you don't necessarily know who it is. So once you get into the lawsuit, you will do depositions or any type of discovery like interrogatories, ask questions so you can identify who the people are. And then now you can place a name on it. But sometimes something happened, but you're not privy to the person's name of what happened. So you replace them. So like a hit and run driver, you may know that it was you may be able to describe it as a male. So you may say John Doe. You know what I'm saying? Somebody was driving the car, but they left. So you don't know who they are. So that's what they are. They're kind of like a placement until they can figure out who it is. Because otherwise, if they know those correction officers' names, they have no reason not to put their name on there. It's not like they get some special privacy and privilege or anything, because police officers get sued all the time. When prisoners have exhausted all their appellate relief, they go and they do what's called habeas corpus, and they actually sue the wardens of the prison that they're being wrongfully detained. That's like their last step, that they're being wrongfully detained or whatnot, to try to get out. So putting names on there is not something that you just keep quiet. So I'm just assuming they just don't know who the names are. Okay. Because of the United States of America's breach, at least 60 BOP officers made unauthorized access to plaintiffs. 60? How does 60 officers? They made unauthorized access to plaintiffs' sensitive, confidential, and private information maintained by the BOP on its electronic system known as TrueView. Some of those BOP officers either shared and or sold the information to third parties, including members of the media and witnesses in plaintiff's criminal prosecution. Defendant unknown BOP officer A accessed plaintiff's private BOP records, including email communication, visiting lists, inmate trust account information, and recorded phone calls with third parties and plaintiff's attorneys without authority to do so. So they had recordings of like attorney client as well. The information was private and concerned personal matters. It was not public information. After unlawfully assessing the foregoing protected information, defendant BOP officer A unlawfully downloaded the information and sold said information to defendant Kebe. Sold said information to defendant Kebe, a popular YouTube blogger with over 1 million subscribers who published the private information publicly without identifying how she received it. Thank you, Can't Fix Crazy, for the membership. Welcome to the Intellects. Defendant Kebe rallied her massive following to harass the plaintiff with the use of the stolen information and created chaos in plaintiff's personal life, even using the information to influence witnesses in plaintiff's Eastern District of New York criminal prosecution. On information and belief, the stolen information was shared with and used by prosecutors from the United States Attorney's Office as a tool to influence witnesses against plaintiff. The sale of the information yielded profits that neither defendant BOP officer A nor defendant Kebe were entitled to and which belonged to the plaintiff, if anyone. Y'all hear this? The Department of Justice Office of the Inspector General investigation initiated a secret investigation into the unauthorized access of plaintiff sensitive information. The department did not inform plaintiff of the investigation and never has. Plaintiff later learned that the investigation resulted in the issuance of search warrants for a BOP computer used by defendant BOP officer A and forensic analysis of the computer. According to an affidavit of Special Agent Matt Laux of the Department of Justice, later obtained by plaintiff's attorney, probable cause existed to believe that defendant BOP officer A committed a criminal violation of 18 U.S.C. section 1030 sub A sub 2 capital B, that is unauthorized access of a computer to obtain information from the Federal Bureau of Prisons. No charges were brought against defendant BOP officer A, and the government has refused to reveal any detail about the investigation, including the identity of officer A. So I hope that answers your question. I kind of answered it before we got to this part as to why it has an unknown officer and John Doe's and Jane Doe's. In short, there has been a cover-up of the rampant BOP misconduct that is ongoing. This is interesting. Even after this so-called investigation, unlawful access of plaintiff's TrueView records continue, even after being put on notice of repeated violation of the CFAA by BOP employees. The United States failed to protect plaintiff and breached its duty to protect his private and sensitive information. For example, defendant unknown John or Jane Doe BOP officer made an unauthorized access to plaintiff's TrueView records and obtained information about plaintiff's trust account funds in August of 2022. That unknown defendant BOP officer divulged information to a journalist for the Washington Post who published the personal information. The publication not only placed plaintiff in a false light, but falsely suggesting he was concealing his resources. The monies were actually generous gifts from his loyal fan base, but resulted in the DOJ confiscating nearly all of plaintiff monies held in his prison trust account, over $25,000. So he had fans that was giving him cash. He had like, wow, okay. Plaintiff was forced to pay for legal services to litigate the unjustified taking of the money, an issue that is now pending before the Second Circuit Court of Appeals. Plaintiff maintains that the DOJ had no authority to confiscate those funds which would have not occurred in any event if the information was not leaked to the public by the defendant, unknown John or Jane Doe BOP officer. Defendant BOP officers committed the torts of invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton misconduct. The defendant BOP officer, including defendant BOP officer A, also committed violation of Computer Fraud and Abuse Act. Plaintiff suffered a multitude of loss and damages as a result of the defendant United States of America's negligence and the torts committed by the defendant BOP officer A and other unknown John and Jane Doe BOP officers, including but not limited to legal fees and emotional psychological distress. Separately, losses in excess of $5,000 occurred as a result of the CFAA violation committed by defendant BOP officer A. The misconduct resulted in an internal investigation by the BOP, an investigation by the DOJ-OIG, and both the seizure and examination of a BOP computer drive. Whoa. So April D said the employee can be sued, but Tasha has nothing to do with how the information was obtained, in my opinion. They are alleging that Tasha paid for it. And if you take information, let me just finish reading. I'm not going to get distracted by the comments. Okay. Jurisdiction and venue. So this is why this is the proper form. Whenever you see the title jurisdiction and venue, a court has to have jurisdiction over you in order to subject you to the rules of that court. This court has subject matter jurisdiction over this matter pursuant to 28 USC 1331, and that this action arises under the laws of the United States of America and is premised on the acts and omissions of the defendants acting under color of federal law. The court further has subject matter jurisdiction pursuant to 18 USC section 1030G, which permits an individual who suffers damage by reason of a violation of CFAA to bring a private cause of action. The action is timely filed, where it is brought within 2 years of discovery of the damage. Okay, let me see what other information they got over here as far as their subject matter before I scroll it up on here and it be something personal. Okay, that's all jurisdiction. Mm-mm. Okay, let me see this. Okay, it's not nothing here. Venue is proper. Okay, let me see the parties. So we got Robert Kelly is the 56-year-old Chicago native. He is indisputably the king of R&B. Yes, that is on there, guys. It's that he is indisputably the king of R&B. He is currently an inmate incarcerated in federal correctional facility. So he's in North Carolina. I'm trying to okay, they didn't put her address. I didn't know if they put like Tasha's address on there because sometimes in order to show when you show the jurisdiction, you also give where they are. So I just wanted to make sure they didn't put no address or something on here. But it doesn't look like it. So let's just go. So it has at all times material to this action, unknown John and Jane Doe, BOP officers were BOP officers assigned to the Chicago MCC and access to BOP's True View system. Although plaintiff does not know the identities of the 60 different BOP officers who made unauthorized access to his confidential information, the BOP does. Plaintiff sues each and every BOP officer who accessed his confidential information without authority and whose identities are available from the BOP. At all times, material to this action, Tasha K is a resident of Georgia, is a popular YouTube host with the YouTube channel called Unwind with Tasha K. She broadcasts content to 1.3 million subscribers across the country, including the Chicago, Illinois area. So it has plaintiff was arrested in the United States District Court, Northern District of Illinois on July 11, 2019 in connection with the 13-count indictment. Shortly thereafter, plaintiff was separately indicted in the United States District Court for the Eastern District of New York in connection with RICO charges brought under case number 19 CR 286. After his arrest, plaintiff was detained in the Metropolitan Correctional Center in Chicago for nearly 2 years until he was transferred to the Metro Detention Center in Brooklyn to face trial in the Eastern District of New York case. And in and around June 21st, 2021, during this period of time, plaintiff was a pretrial detainee. While detained in the MCC, I think we're getting somewhere now. I think now we about to start cooking. While detained in the MCC in and around January 2020, plaintiff's longtime girlfriend, Jane Doe, began behaving in a hostile and accusatory fashion toward the plaintiff without explanation. Jane Doe was furious with plaintiff and unexpectedly began causing stress and conflict in the relationship. These arguments related to money issue, romantic issues, and other highly personal issues. Plaintiff later learned that in and around that time, Jane Doe abruptly began cooperating with the government, which led to her becoming the government's star witness against him in the Eastern District of New York prosecution. In and around that time, defendant Kibi, a popular YouTube blogger, began publishing information to her 1.1 million subscribers and other viewers' private information about the plaintiff to which she should not have had access. Defendant Kibi did not reveal how she received said confidential information. Just by way of example, on November 7th of 2019, defendant Kibi posted a video on YouTube titled R. Kelly Can't Control His Girlfriends While Behind Bars. Kibi told her viewers that the information came from a, quote, phone tap somewhere, end quote. Kibi disclosed information that appeared to come from plaintiff's prison calls with Jane Doe and his girlfriend, J.S. Kibi appeared to disclose private and personal information about plaintiff's romantic relationships. Are y'all hitting that like button? Make sure you hit that like button and subscribe. For those of you that don't know who I am, my name is Pam Esquire, also known as the Law Intellect. You guys are the intellects, and you're also the social media jurors. Some of you guys are intellectual paralegals. Some of you guys are intellectual investigators. But whatever your position is, we try to gather all the information and then we come to our own conclusions. Of course, what our conclusions are don't really matter at the end of the day because we're just social media jurors. But we like to analyze cases, and then we're doing nothing different right here on this R. Kelly case. Again, these are just allegations. Anybody can file a pleading. And so nobody is liable at this time. Now let's continue with our programming. Make sure you hit that like button and subscribe if you have not done so already. Defendant Kibi proceeded to divulge to her YouTube viewers that the contents of plaintiff's prison calls with his girlfriend and others, emails, communications about his private life, and legal issues with numerous people, visitor logs, and trust account information on numerous other occasions, again, without disclosing from where she received the information or how she received the information. Plaintiff was incarcerated and had no ability to watch Kibi's YouTube channel or learn the specific information that was being said by defendant Kibi. At one point, plaintiff visited with Jane Doe and was shocked and confused when Jane Doe accused him of making certain statements concerning his personal life that were only shared with plaintiff's lawyer at the time. Jane Doe refused to divulge how she received the information, but claimed that she was privy to plaintiff's conversation with his attorneys. Oh my goodness. Plaintiff had no idea how certain private information was making its way into the public domain. In early 2020, the BOP went on a complete lockdown as a result of the pandemic for a year. Attorney visits were conducted entirely by phone calls, and eventually Zoom visits and face-to-face visits did not resume until late 2022. See, this is what, see, federal must be different because from a state side, you can actually request a phone call that is not recorded as an attorney. You know, they say they won't record it. I still go see my clients face to face and do attorney visits because I just don't trust nobody. I am from 7 Miles, so my trust level, I have trust issues. Even though they say that they're not going to record it, in my mind, I'm like, yeah, all right. But it's supposed to be when they know that it's an attorney visit, you use a phone that's not even doesn't even allow recording capabilities, from my understanding. But maybe federal is different because again, federal doesn't even they don't release their calls, they don't release mug shots, they don't televise in the courtrooms, they don't allow cameras. They do have a whole different setup there as well. But that's crazy. Like somebody comes to you for a visit and they're telling you your conversation with your lawyer that you know you just had with your lawyer, but you guys had a phone visit, attorney client phone visit, because that's the only way you can really communicate because of COVID. You couldn't see your client face to face. Yeah, I can see that being concerning if that happened. It is unclear how many of plaintiff's attorney-client communications were shared with third parties by defendant BOP Officer A, or why those communications were being recorded at all. I could have just kept reading because I'm not understanding either. Why would those be recorded if you know they're attorney-client? In June 2021, plaintiff was transferred to the MDC in Brooklyn, New York, to stand trial in his RICO prosecution. His federal RICO trial commenced on August 9, 2021. A jury returned a verdict against him on September 27, 2021. Plaintiff's current counsel filed an appearance in the Eastern District of New York case in October 2021 for the purpose of handling post-trial motions and the eventual appeal. Her role expanded after plaintiff's original trial lawyers withdrew from the Eastern District New York case by January 2022. Undersigned counsel filed an appearance in the Northern District case on February 18th of 2022, and with her legal team began preparing for plaintiff's Northern District trial scheduled to commence in August. After counsel's legal team received information about the unauthorized and illegal taking and selling of plaintiff's private information, counsel sought discovery from the government. On June 14, 2022, attorneys for the government produced to plaintiff's counsel an application and affidavit for a search warrant under the case caption "In the matter of the search of the HP desktop computer bearing a serial number," and it has all the numbers. The materials did not include plaintiff's name or any BOP officer name. Neither plaintiff nor his counsel had access to the anonymously filed search warrant application and affidavit until it was produced by the government in June 14, 2022. The government refused to provide any additional information despite plaintiff's request. According to the materials produced in June 2022, Special Agent of the Department of Justice of the Inspector General executed an affidavit in support of a search warrant for a computer located in the Northern District of Illinois related to violation of 18 U.S.C. Section 1030, that is unauthorized access of a computer by obtaining information from the Federal Bureau of Prisons. The agent averred that the OIG received information from the BOP. OIG is excuse me. The OIG received information from the BOP that unknown BOP Officer A was suspected of accessing sensitive law enforcement information maintained on the BOP's electronic systems and providing that sensitive information to an individual who then released the information on social media platforms. Specifically, the warden of the MCC in Chicago reported an allegation of staff misconduct to the BOP Office of Internal Affairs when MCC staff began aware that unknown BOP officers, including defendant BOP Officer A, had stolen plaintiff sensitive information from the BOP's electronic system known as the TrueView system without authority to do so. The BOP's TrueView system is an application that contains information on inmates, including emails, telephone calls, visitation lists, and inmate funds. The TrueView system contains information from various other applications and systems existing on BOP's network infrastructure. The information available on TrueView includes information from BOP applications TruePhone, the inmate telephone system, which houses recordings of inmate telephone calls. Whew, y'all all right? You guys with me? David said, I think we should all sue them. You said we should all sue the United States of America. Oh, David. He said we should all sue. He said, yep, I'll be free. Yeah, yeah. I wouldn't trust it anyway. But I guess you don't have a choice. Okay, my sister says she with me. I know it's a lot. It's a lot of reading. This is a long lawsuit, but it's a lot of meat and factual information in it that they're alleging. I wasn't familiar with the stuff that that was alleged during this time. I kind of heard about it in passing, but I really didn't know it was this deep. The information constituted inter alia private conversations between plaintiff and Jane Doe and his girlfriend JS. The communications related to personal and private relationship matters, financial issues, and even attorney client matters. Although plaintiff did not know at the time how Jane Doe obtained the information, when plaintiff had the opportunity to learn of the contents of Agent Lowe's affidavit, he deduced that the information had been stolen by the unknown defendant BOP officer, sold to defendant Kibi, and then exploited for profit when defendant Kibi divulged it to the public and to other third parties, including Jane Doe. My mama. Defendant Kibi recently admitted on one of her broadcasts that she did obtain the information from defendant BOP officer A and not only disseminated the information publicly, but provided additional information to Jane Doe and others, including Jane Doe's family members, for the purpose of interfering with plaintiff's criminal prosecution. Lord, say it ain't so. Tasha ain't say that. She did not say that on her platform. You telling me on one of her broadcasts, you saying Tasha K admitted that she obtained this information from Officer A and not only disseminated the information publicly, but provided additional information to Jane Doe and others, including Jane Doe's family members, for the purpose of interfering with the criminal prosecution. This about to get bad, y'all, because I'm sure this attorney is going to use this from the appellate for an appellate purpose or some type of post-conviction motion, because if any of this information became known to witnesses and it somehow affected how they testified, or even if they can really prove, because it sounds like upon information and belief, they believe that the prosecution had some of this information. If they knew about it and didn't say anything, wow. The release of this private information on the internet created a feeding frenzy about plaintiff's personal life, his relationship with Jane Doe and JS, and resulted in the termination of certain important relationships that plaintiff enjoyed with other individuals. The unauthorized release of the information led to a physical fight between Jane Doe and JS that made national news. The theft of thousands of dollars in chaos, discord, and plaintiffs. So we know who they talking about. Remember those two girls that did the interview? That was living with them, and they was like they was okay with the girlfriends, and then all of a sudden one of them left. So that's JS. One of them left or whatever, and the other one, she's still sticking by him. And they got into a fight, and she put it all over the Instagram that they had gotten into a fight. Oh my goodness. Robert Sylvester. Furthermore, because information about plaintiff's visiting list and trust fund balances became public news, Plaintiff was no longer able to enjoy certain important and supportive relationships with people. Defendant Kibi released the names of certain individuals who supported plaintiff, publicly shamed those people, calling them enablers, and interfere with those relationships. So you know how Nestor was talking about somebody was going to pay for his was going to pay his bond, but they wanted to remain anonymous. Clearly, some of these people, I guess, that were trying to support R. Kelly, they were doing it because they thought they would be, remain anonymous. But because allegedly the names were divulged and they were publicly shamed for supporting. Y'all got it. You guys picking up these initials. You guys are picking up what they putting down. Understandably, plaintiff associates did not wish to be harassed or have their employment put in jeopardy because of the illegal conduct of defendants BOP officer A and Kibi. Plaintiff suffered significant emotional distress as a result of the release of this information and further worried about what other private information was in the hands of third parties. Both before and even after plaintiff learned about Agent Lowe's affidavit, plaintiff spent sleepless nights distressed and confused how his private conversation had been leaked to the public and who was responsible for it. Importantly, plaintiff suffered emotional distress because he did not feel at liberty to freely speak with his attorneys. I can totally see that. Yeah, wouldn't want to talk to you no more on the phone. Plaintiff learned that his attorney-client communications were not only recorded, but information from those calls were released to Jane Doe and presumably others. Plaintiff did not and still does not know the extent to which his private information has been divulged publicly. The agent investigation revealed that from the period of July 15th of 2019 through January 8th, 2020, 60 different BOP officers had accessed plaintiff's TrueView records, including defendant unknown BOP officer A. Indeed, defendant's unknown BOP officer A engaged in unauthorized access to plaintiff's TrueView records a whopping 153 times. My goodness, you were nosy if this is true. To this day, plaintiff still does not know the extent of his damages, injuries, and loss, as the government has refused to disclose to the plaintiff information about what the investigation revealed and the precise nature of the stolen information. Well, you're going to learn now. Robert, you're going to know now because you have filed this lawsuit, and now you're going to have a moment of discovery, and you're going to be able to subpoena. You get a subpoena, you get a subpoena, you get a deposition, you get a deposition, you get a request to produce. You give me some initial disclosures. You're going to be able to get everything you want now. Subject to that it doesn't get dismissed. They can try to file a dismissal on a pleading if they feel like it's not a cause of action, but this is sounding real deep to me. Agent Lowe's investigation showed the private and sensitive information from plaintiffs' TrueView records became part of defendant Kibi's content on her Instagram post on January 12th of 2020 and videos on November 7th, 2019, November 8th, 2019, and December 22nd, 2019. The information included private information about plaintiff's literacy, medical issues, private information about his romantic relationships. At no point did defendant Kibi reveal the identity of the person who provided her with the information. Indeed, the identity of the individual who revealed the information to the defendant Kibi remains a mystery to this day. The agent's investigation further showed that unknown BOP officer stole plaintiff's records from True TV systems, scanned those records, and then emailed that scan to third parties, including defendant Kibi. The content of those materials were published on defendant Kibi's YouTube channel. Defendant unknown BOP officer A was not the only officer who engaged in unauthorized access of plaintiff's private records. Indeed, the agent reported that at least 60 officers had made unauthorized access to plaintiff's confidential TrueView records during his 6-month period. The BOP knows the precise identity of those officers, as do the officers who engaged in this unauthorized conduct. Even after the BOP discovered the rampant violation of the CFAA, they allowed the behavior to continue. The plaintiff learned that in and around August 4th of 2022, an unknown BOP officer made an unauthorized access to his TrueView records and obtained information about plaintiff's inmate funds. That unknown BOP officer leaked information about the balances of funds in his trust account to a journalist for the Washington Post who published an article with the stolen information provided by the defendant unknown BOP officer. Immediately after the journalist divulged the information, the funds in plaintiff's trust account were confiscated by the United States Attorney Office. Plaintiff was forced to hire counsel to litigate whether the U.S. Attorney's Office had the right to confiscate the funds, where no restitution judgment had been entered against plaintiff, and he was not in arrears for paying any court order fees or costs. Plaintiff promptly filed a notice of claim on November 14, 2022, and served his claim to the appropriate federal agents for administrative settlement under the FTCA, requesting $1 million or more. So before you can sue the United States government, and it's the same things when you sue the state, they have court of claims, and usually you have to file a notice that you're about to sue them and try to work it out before you file a lawsuit. By letter dated June 15, 2023, plaintiff's claim was denied in writing by the North Central Regional Office of the Federal Bureau of Prisoners, and such denial was sent by certified mail to plaintiff's counsel. This complaint comes less than 6 months after plaintiff's claim was denied. His first cause of actions against the defendant, United States of America. The Federal Bureau of Prisons is a United States federal law enforcement agency within the U.S. Department of Justice that operates U.S. federal prisons and is responsible for the care, custody, and control of federal prisoners. Defendant, United States of America, owed a duty of care to the plaintiff who was incarcerated in the BOP. The defendant stood in such a relationship with plaintiff that the law imposed on the defendant an obligation of reasonable conduct for the benefit of the plaintiff, including protecting his confidential and sensitive information, including attorney-client communications, and to protect him from exploitation from its employees that could result in harassment and prejudice to his pending criminal cases. Specifically and consistent with its own policies and regulations, defendant United States had a duty to ensure that plaintiff confidential and sensitive information was accessible to only those BOP officers with a legitimate basis to review it. The BOP had a duty to protect the sensitive information from disclosure and theft, and to protect both plaintiff and exploitation by BOP personnel. As set forth in detail above, reading too fast. The defendant, United States, breached that duty when it permitted countless BOP officers, including unknown BOP Officer A, unlimited access to the information, the ability to download it, and the ability to sell and or divulge, in which unknown BOP Officer A did when she provided private information to defendant Kebe. The breach further caused the publication of confidential information obtained from plaintiff's trust account, which was stolen and shared with other media sources. Even after the BOP became aware that its employees were repeatedly accessing plaintiff's private and sensitive information without the authority to do so, it took no steps to prevent the misconduct. The breach was the direct and proximate cause of plaintiff's injuries, namely the release and the dissemination of his private and confidential information to third parties and the public at large. The public dissemination of private communication, and kind of being repetitive, including attorney-client communication, interfere with plaintiff's relationships, led to harassment from the public, and caused serious prejudice to plaintiff's defense. Caused serious prejudice to plaintiff's defense. The defendant, United States, knew or should have known that by allowing unfettered access to plaintiff's private information, BOP officers would access, steal, and exploit that information for financial gain or clout. Yes, they use clout. And so he suffered emotional damages and distress and all of that stuff. So let's stop before we go to the second cause of action, because we got about 5 more pages in this complaint left. So I recall when the two girls did the interview that everybody was like, why did you guys do this interview together and all of that? And they were sticking beside him. And then it just seemed like all of a sudden a light bulb happened with one of the young ladies where she didn't want to be a part of it. And she was talking bad about R. Kelly when she was rooting for him at first. Then all these accusations kind of came out about how they were living. And then she got into a fight with Jocelyn. No, not Jocelyn. What's the whatever? She got into the fight with the other one. I don't even remember their names anymore. It's been so long. She got into the fight. So all of this had to do with the dissemination of this information, allegedly. This is what caused all this chaos that was occurring. So R. Kelly's sitting behind bars, according to them. He's just confused. He's like, how does this lady know all the stuff I'm saying? Now, obviously, he probably was saying some things that he didn't want her to know. He was probably talking to some other people that she probably wouldn't have wanted him talking to. And the attorney-client situation, your attorney and counselor. So he probably, however he was feeling or whatever was going on, if that was being recorded, she was able to get that as well. So they're alleging that this is what caused a lot of the conflict that we saw play out in social media. But we also saw the sudden about face of one of the girlfriends where she testified against R. Kelly. So that's where all of this came from. That's interesting. Okay. Jocelyn is okay. Azriel is the okay. Out. They can stay JS and Jane Doe. You said she read the documents. Andrea said she read the documents word for word. Wow. One of the women had a baby recently. No, that was a rumor, I think. R. Kelly came out and said that it wasn't true. Yes, y'all, please hit that good like button. I would appreciate that. Oh, why isn't he suing the Post? What do you mean, Kim Vaughn? I know I'm late with these comments. I just want to make sure I catch a couple of them. How does he know any information was bought? Well, I'm pretty sure didn't Tasha K say that she was interviewed and she was cleared or something? Because clearly everyone was, there were no charges pressed. And so if you guys read, thank you so much for the 1999 super chat, Sonia Vic. I appreciate you so much. If you guys, the press release, okay, let's read the press release right quick as to why this lawsuit was filed. The reason why it was filed, from what I'm gathering, is mainly because nothing happened. What's the name of these people? I gotta find the press release right quick. So they said that they filed it because nothing was happening, that they weren't going to press charges against anyone. Bonjean, I think it's a law firm. Okay. They have today, November 13, 2023, the Bonjean Law Group filed a complaint on behalf of Robert S. Kelly. Sorry. In the United States District Court for the Northern District of Illinois against the United States of America and its employees, unknown BOP officers and they got all of the different reasons. The complaint alleges that certain BOP officers conspired with each other and a YouTube blogger, Tasha K, to access and steal private and confidential information from BOP databases. These people got gall. Like the United States government, y'all, you want to go in computers? That's just crazy to me. These people are just so fierce. They don't scare easy, because I'm like, have my nerves bad. So it has including emails, communications, recorded phone calls, trust account information, visitor logs, and attorney-client communication. The information was protected and personal relating to Mr. R. Kelly's private affairs. It was disseminated to third parties and the general public not only for pecuniary gain, but for the purpose of interfering with his defense to pending criminal charges and to harass and harm him. Mr. Kelly must now bring this lawsuit to get answers and justice because despite opening an investigation into the serious misconduct, the DOJ ultimately declined to indict the wrongdoers and allowed the misconduct to continue. So they're bringing it because the DOJ declined to bring any indictment based on any of these alleged violations. Even though, according to them, the subpoena they got or the affidavit for the application for the warrant said that they found probable cause, they still declined to bring charges. St. James said, folks get fired from my government job weekly for accessing baby dad's information and other. Yes, I have someone that came to me who was being harassed. She kind of got herself in this situation, but how the person chose to handle it was wrong because he was allegedly a government worker. And so what he did was access a lot of her information. So everything she did, she could open up a social media account and put Piggly Poo on it and not even put anything near her name. And he would know it was her and told everybody to basically harass her and whatnot. So finally, she found out the reason why he was able to do this allegedly was because he was a government worker. So he had this access to the databases or whatnot. And so she reported it, and that's what made him stop because I think he ended up getting fired for that. So that's why I'm like, they know you're going to use your login information. There's fingerprints to that. I know here we have what's called a lien system. And so they don't even like officers because I guess back in the day, you can say, I got a brother that's a police officer. I want you to look this name up and run a background check or whatever you want to do. You can't do that. Like you have to put in your own personal information. So it's a fingerprint. Whenever you look up somebody's name, it better be because you about to arrest them, you're behind their car or whatever, or that is grounds to be terminated. And it's a crime. So I know the government has to be very, very strict on that. Unless they just worked there so long that they knew that nobody really paid it any attention. I don't know. So this is very interesting allegation, and that this can even happen in a federal government system. This is crazy. So Michi said the responsible Department of Prisons officer retired without punishment. Wow. Who said that? Said it was a great payday to take a chance losing their federal job. So yeah, I'm assuming though that there were conversations with some of these people, obviously. So that's probably how they know if payment was given, payment was received, or tracing bank accounts. I mean, their investigation, we don't know how deep it went. But somehow there is a belief, according to this document, that it was for money. And if not even in hand, of course, you get paid for your YouTube, you get paid for, the other other platforms that you have. I guess she could be talking about that as well, but when she talks about a pecuniary type gain. Oh, man, this is heavy on a Monday. Thank you. Thank you so much, Hope, for the generous cash app. I appreciate you so much. But let's just guess we get back to the document. You said because they're in a small town and the people do work there forever a lot of times. I see in one. Yeah. Well, the thing with the federal government is different on what they release again, because we can get mug shots and stuff from state. We get the mug shot. You see how fast we got Trumps in Georgia. We can get jail calls in Georgia. Here, you can get some jail calls. It just depends on if they kept them. I've gotten jail calls as public record here as well. where I'm at. So it a lot of that stuff depends. It's more from a state side, you have more things that are public information. The federal side doesn't allow you to have information like the state does. So it's very different. 875 of you guys in here. I appreciate all 875 of you, but I would appreciate you more if you hit that like button and subscribe to the channel. We got goals over here. We got goals. Okay, guys, let's get back. I had to take a break because all this reading was. So the second cause of action is invasion of privacy, and that is against the BOP officers and Tasha K. So defendant unknown BOP officer A and other unknown BOP officers committed repeated unlawful and unauthorized intrusion into plaintiff's confidential and sensitive information as defined by the BOP. Thank you so much for the cash app. The intrusion is highly offensive and objectionable to a reasonable person. Although certain privacy rights are forfeited when an individual is arrested and incarcerated, plaintiff, who was not yet convicted, still maintained a recognized privacy interest in his communications, visitor list information, trust account information, and his attorney-client communication per the BOP's express policies. This information, set out in detailed fashion above, was defined as private and confidential by BOP itself. The information was not for public consumption. Plaintiff had every right to trust that his messages with third parties, his phone calls with friends and family, and lawyers will remain under the care and control of the BOP and not published to the media for financial gain or in connection with interfering with his right to obtain a fair trial. As reflected above, the communications were private in nature. They related to personal and family problems, romantic interests, health problems, literacy issues, and issues related to the defenses of his pending criminal cases. Clearly, plaintiff's conversations with his girlfriend, J.S., were personal and private, as were plaintiff's conversations with his attorneys. Simply put, the information was not public information. The intrusion caused plaintiff anguish and suffering. The release of his private communications were broadcast to the public. The communications led to the loss of important and close relationships, conflict and chaos in plaintiff's life, harassment, and extreme paranoia. Plaintiff was isolated and fearful to communicate with his attorney or other third parties where he knew that his private information and conversations could and did get released to the general public for mass exploitation. This violation even led to plaintiff having to seek psychological care in the MCC for psychological stress caused by his intrusion of privacy. You better work them damages, Robert Kelly. Robert said, I'm going to get a doctor to tell me that I'm stressed out. I'm not just going to say I'm stressed out. I'm going to go see a doctor who is going to diagnose me. I'm going to give me some anxiety pills, and then I'm going to sue you for intentional infliction of emotional distress because you have stressed me out. That's how you show your damages. Good evening, Patricia. Welcome. Third cause of action is conversion. You know, conversion is theft. And that's against the BOP officer, A, and all the other ones. They don't know their names. We don't know none of their names, guys. And defendant Kibi. So she's in another count. Defendant unknown BOP officer A made repeated unauthorized access to plaintiff's private and sensitive information. She downloaded plaintiff's private information, including email communications, recorded phone calls, visiting lists, and trust account information, and sold the information to defendant Kibi. Defendant Kibi used the stolen and private information for financial gain by divulging it to millions of people via her YouTube platform. The information belonged to plaintiff and was maintained by the BOP on behalf of the plaintiff, but for BOP policies assuring the plaintiff that the information would not be disseminated publicly, plaintiff would never have made certain communications. Defendant BOP officer took unauthorized control of the property and shared it with third parties, causing plaintiff serious damages as detailed above. The fourth cause of action is called civil conspiracy, and that is against all of those BOP officers and defendant Kibi. As described more fully in the preceding paragraphs, The individual defendant BOP officers acting in concert with one another and other co-conspirators, known and unknown, conspired to accomplish an unlawful purpose by unlawful means. In addition, these co-conspirators agreed among themselves to protect one another from liability for depriving plaintiffs of his rights. In furtherance of the conspiracy, the defendant BOP officer, including Officer A, committed overt acts and were otherwise willing participants in joint activity. The violation of Illinois law described in this complaint, including defendant's invasion of privacy and violation of the federal computer fraud and abuse, were accomplished by defendant's conspiracy. The misconduct described in this count was objectively unreasonable, was undertaken intentionally and in total disregard of plaintiff's rights. As a direct and proximate result of this misconduct, plaintiff suffered injuries, including but not limited to emotional distress, as is more fully alleged above. The fifth cause of action is, you guessed it, guys, we guessed it ahead, intentional infliction of emotional distress. Told y'all. And I promise y'all I ain't read this at all. You did not read this complaint. The acts and conduct of the individual defendants as set forth above were extreme and outrageous. The defendants intended to cause or were in reckless disregard of the probability that their conduct would cause severe emotional distress to plaintiff. The individual defendants' actions and conduct directly and proximately caused severe emotional distress to plaintiff and thereby constitutional intentional infliction of emotional distress. The misconduct described in this count was undertaken with malice, willfulness, and reckless indifference to plaintiff's rights. As a direct and proximal result of defendant's wrongful acts, plaintiff suffered injuries, including but not limited to emotional distress, as is more fully alleged above. There's also a sixth cause of action of IIED, and that's against all the unknown BOP officers and defendant Keeby. At all times relevant to this complaint, the defendant had a duty to refrain from willful and wanton conduct. Notwithstanding that duty, these defendants acted willfully and wantonly through a course of conduct that showed an utter indifference to or conscious disregard of plaintiff's rights. As a direct and proximate result of defendants' wrongful acts, defendants suffered injuries, including but not limited to emotional distress, as is more alleged above. The seventh cause of action is violation of the Computer Fraud and Abuse Act. And that's against unknown defendant BOP Officer A. As detailed above, defendant BOP Officer A intentionally accessed information from an agency of the United States of America, namely the BOP, without authorization and divulged and sold the protected information to the third parties. Specifically, defendant Officer A accessed the True View records of plaintiff, a BOP prisoner, without authorization, or she or he exceeded authorized access in order to obtain True View records, which consisted of email communications, recorded phone calls, visitor lists, trust account information, and attorney-client communication. The information accessed and retained by defendant Officer A from a BOP computer has been determined by the United States of America to be protected against unauthorized disclosure. Defendant BOP officer sold and transmitted that protected information to a third party who publicly disseminated it. A search warrant application filed by a special agent shows that probable cause exists to believe that defendant Officer A committed the offense of 18 U.S.C. 1030 A2B. Losses in excess of $5,000 occurred as a result of CFA violation committed by defendant BOP Officer A. The misconduct resulted in an internal investigation by the BOP, an investigation by the DOJ, OIG, and both the seizure and examination of a BOP computer and hard drive. Wherefore, we are at the end, guys. This is called the prayer for relief. Plaintiff Robert Kelly prays this court enter judgment in his favor and against defendant United States of America. Unknown BOP Officer A, unknown John and Jane Doe BOP officers, and Tasha K, awarding compensatory damages, costs, and attorney fees against all defendants And punitive damages, they want them to be punished, y'all, against each of the individual defendants in their individual capacities. And they want them punished individually. And for such further and additional relief as this court may deem appropriate and just. And he demands a trial by jury. Respectfully submitted, Robert S. Kelly. And there you guys have it. Yes, that is Bill Cosby's attorney. Yes. Yeah. Yes. R. Kelly is suing a whole lot of people right now. He said 60 BOC, and then he said the United States of America, the whole government. Everybody getting sued. Patricia said, I don't blame him, but he's going to have to stand in line. That was a lot, wasn't it? You think he's trying to pay off his victims? If they can prove, that'll be very, very interesting. That's a strong allegation to say. Well, she said upon information and belief. So obviously she's not 100% sure, and perhaps further investigation. Because I think people believe that just because you're an attorney, you just have subpoena power and you can just go shoot off subpoenas everywhere. But you have to be in litigation, so your hands are tied. We only, outside of litigation, we pretty much have the same rights that you have as far as getting Freedom of Information Act information, or stuff that the government or the state agrees to divulge to you, and they give them heavily redacted and all of that. But when you're in litigation, i.e., you file a lawsuit, you get subpoena power. So you can subpoena. Discovery is very broad. Discovery is what you call when you're trying to get your evidence and get the information from the other side. And it's very broad. So it's reasonably calculated to lead to information. So it may not be direct information, but if it's a name that if I talk to them and depose them, they may be able to give me more information, then it's discoverable. So it's very broad and far reaching under the federal rules and most state rules. Therefore, this is the route you go if you really want to get information, because they're going to have to turn things over, they being the government, and they're going to have to do depositions if it goes that far. Again, I surmise that the United States of America, when they get the prosecutor that is going to, not the prosecutor, but get whoever is going to defend, I think it may be the AG, whoever is, because I sued the state. Yeah, when I sued the state, the AG's office takes over. So whoever defends on behalf of the United States, their first response is probably going to be to try to dismiss this case. And you'll see various reasons that they have immunity and all of that. That'll be their first defense, that they have immunity from being sued. So it's going to be very, very, but I think some of these claims may stick. And then if that, you just need a couple of them to stick for you to stay in the case and be able to get the subpoenas that you need. Now, it sounds like what they are alleging, and you guys can tell me if this is what you're hearing, that this stuff affected his cases and may have affected why he was found guilty. So how will this affect his defense? How will this affect his criminal cases? Because I think the state case in Chicago, they dropped it. And he was found guilty on maybe some of the counts in the federal Illinois case. But he got the real hit on that RICO case in New York, was what he's doing some real time for. It's a lot. He said the woman he chose says there was a lot of evidence in his case. Well, I wasn't there, so I'm gonna take your word for it. But what did they find him guilty of? He had a RICO. Well, they were from what I gather. Again, I didn't cover R. Kelly. I don't even think I had a YouTube. I only had a YouTube channel for like a year, so they talking about stuff in 2019 and 20. But I believe it was they made it a RICO charge, if I recall correctly, and you guys can correct me, because there were alleged minors going over state lines or something. So they made it into a RICO charge. I'm not really sure. Oh, she said, yeah, minors across state lines. Okay. He said the Washington Post used information about his trust that caused him to lose money. Why isn't he suing them? It sounds like someone just gave the Washington Post information. And again, I'm just guessing. They just gave them information and they reported it as a reliable source. Now with Tasha, I think they're alleging it got a little bit deeper, like the financial, I guess from a newspaper, you kind of get financial gain. People buy the newspaper, but it doesn't go personally to the editor. They work for the newspaper. But I think they're alleging that she paid for the information. She made, she may have alluded, and again, this ain't me. This is what's in the document. She may have alluded on some of the lies that, she knew it came from somebody on the inside. So that kind of meant that you weren't supposed to have this information. But that's a good question. I guess you can sue everybody, huh? If you sue the United States of America, shoot, you might as well sue everybody. So let me see. Michelle Letts said she that what Tasha ain't you ain't got it. Robert said I ain't got it. Robert, I ain't got it. Michelle says she ain't got it. Kindly remove my name from the list of those included in the United States. Will I defend you? We need a good lawyer. Heck, I'm being sued like y'all. I'm a United States citizen. Who gonna defend me? Oh, April D said the DOJ is mostly liable. Well, you already know the taxpayers. Who do you think is gonna foot the bill for this litigation? Diane said, if this case is close to having legs, which I believe it does, this will legally epic because of the parties involved. Thanks so much for taking the time to write. Oh, you're welcome. You're welcome. Yeah, this is gonna be interesting. I ain't gonna lie. I want to see the responses. Oh yeah, there's gonna be a lot of discovery. You said everybody seems to think this lady is loaded. You know what? I don't even think they really want money from her like that. I think to me, it sounds more of a strategy because if I can get access to this information and I can prove some of my theories, this can affect his case. Like this can affect him in his criminal cases. So yeah, you said cartel. You know what, Van Varner. We're just bringing the news, Van Varner. That's it. You said his lying victims have always been. I don't even know what that means. I don't know. You're gonna have to help me, Kia. But you clearly like R. Kelly because I see the picture. You should have had infamous Sylvia on this live to read the documents. I should have had her on the live. Um, you said if we are all defendants, we need to know all the info. Oh, oh, Aretha Johnson. Whoa. Thank you, Betty G. All right, y'all. That's that. I have blabbed from 5 o'clock dang near till now. So I hope you guys have a good Monday. Make sure that you we are going to stay up on this case. So now you guys know that it is true. We read the press release that it was a lawsuit that was filed today. there was a lawsuit filed. It is a lot going on in this R. Kelly stuff. Again, I wasn't really following it like that, but I'm on it now. I am on it. I am on this case because this is very interesting. I like this type of carrying on where you like, I'm suing the United States. I'm suing the United States. There's some carrying on right now. So, all right, guys. You guys have a great night again. Thank you to all of those that donated. You didn't have to, but I appreciate you, and I'm glad that you did. Make sure you like, share, and subscribe. And I'll be right back here when more interesting and breaking news happens. But until then, you guys have a good night. I hope you guys enjoyed the live. Make sure you hit your hearts on your way out and let me know.